Tēnā no tātou, e te tia te tā, e te nui e te rahi. Tēnā koutou I rā me mene mai nei, I tēnei ahi ahi. So a warm welcome to you all this Wednesday afternoon. We're pleased to have you all, given the breadth and depth of experience on screen. It's only right that we open this webinar accordingly. So I'll open us with karakia. My name is Johnny, Cultural Lead here at Te Kahu Raunui, Sports Integrity Commission. Following karakia, I'll throw it over to my man here on the right, Paul, and we'll go forth from there. So without further ado, anei tā tātou karakia. Tīkina atu rā te pūtake o ngā kōrero I te wānanga. Tīkina atu rā te hautapu a ngāriki. Kau whatateo tāne te wānanga, ki rongi e nei ruānuku. Kia koi te matapuinanga, mai matapu iho iho, ka whakamawai kia tīna. Haumi e, hui e, tai e. Kia koe te rākau, Paul, over to you.
Kia ora, Johnny, and kia ora koutou to everyone out there in the team's land for joining us at this webinar. It's been really gratifying to see how many people have shown an interest in this subject. It reflects what we've been hearing as well, that the mechanics of adoption are something that you want to know more about. So we're very fortunate to be joined by Nigel Sterling and Tennille Burnside from Gibson Sheat. Those of you who have been operating in the sports world may well know them already, very prominent and very active, advising NSOs and all sorts of sports organisations over the years. So we're very grateful for their expertise. I think they're known as lawyers you might actually want to know and talk to. The rest of us get given a wide berth when it comes to the legal community, but we're those good sorts of lawyers you actually want to hear from. So thank you to them and thank you to you for joining us. This webinar is being recorded, so that will be able to be circulated subsequently so that any of your colleagues who haven't managed to make it along to this session can join us. But yeah, as I say, this is being recorded. It's one of the reasons I wore my best shirt, so do bear that in mind. We will have a Q&A function operating throughout the webinar. So use the Teams Q&A function to throw any questions you have in here. We're actually hopeful that we can leave a decent amount of time for questions because given the breadth and wide nature of the different organisations that we deal with and who are on this meeting, it's difficult for us to anticipate every situation that might arise. So it's going to be really valuable and useful for us to have those questions from you at the end. So chuck them through as we go. We'll filter those and hopefully get to them, as many of them as we can at the end. So thank you. So obviously I'm Paul O'Neill. I'm the General Counsel here at the Sport Integrity Commission. One of the things that I won't take for granted is that you're all absolutely immersed in the Integrity Code. It's my good fortune to have that status of living and breathing this thing, but you guys have got day jobs and better things to do. So I will start with a general introduction just so you appreciate what it is we're talking about before we move and dive right into the mechanics of how you might adopt it. So the Integrity Code is voluntary. It contains minimum standards for the sport and recreation sector. It's not just sport, it is recreation as well, which is pretty uniquely broad in terms of the jurisdictions that other countries have adopted, but that's the approach we've taken. We think it's really effective and appropriate. It is voluntary. It is not compulsory. It is not a Crimes Act for sport. It is not linked to funding. It is not linked to any other lever or mechanism other than being the right thing to do, in our opinion. So the basis upon which we are wanting sports and recreation organisations to adopt the code is primarily to prevent and address harm in sport and recreation. That's why we think it's a good idea, not because it's compulsory, not because there's money in it, because it's there to prevent and address the harm that your participants might suffer. In particular, we've called out keeping children, young people and adults at risk safe through the consultation process and through the legislative process. It was really clear that group in particular are disproportionately suffering harm in the sport and recreation sector. So we're making no apologies for calling that group out specifically, saying we want to give them particular attention and focus in terms of preventing harm. We want to improve the integrity capability of organisations. Realistically, the Sport Integrity Commission is a relatively small organisation. We would need thousands of people to do integrity for every organisation that existed out there. We're not set up to do that. We couldn't do that, and it wouldn't be the most effective thing. So we want to work with you. Part of these webinar conversations contributes to that. Basically, partnering with you and helping you do a good job for your participants, giving you the resources, the guidance and the advice that you need to raise integrity. Also, we're trying to really respond to what organisations have asked for in terms of what does good look like. So what are those minimum standards, and what do we actually need to do? There are pockets of excellence out there. There are people doing some amazing things, but part of the Integrity Code's real aim and ambition is to set out what those minimum standards are and what you should be doing to achieve a good standard of integrity. And finally, it explains our role when there are serious integrity issues. As a commission, we're very much in a supportive, partnering, facilitative role. Every now and again, we will, as a regulator, have a role we need to intervene, and there will be sanctions that we might want to apply, but that's very much not our starting position. But the code does explain where we will intervene, where we will engage, and what that role will look like. And as I say, it's in response to the sector saying we need some help here and we need some guidance on what is good and what is not, and what responses should be to integrity issues. That's a really brief introduction. What I'll do now, because I know you're all here to hear about adoption, and I thought just before I go to Nigel and to Neil, set the scene a little bit for the timing and notification requirements for the adoption process. There's a couple of myths or misconceptions I want to dispel firstly. Those of you who want to go on our website, you'll see a very good and comprehensive adoption guide, and I would encourage you to do that if you haven't seen it already. One of the things to cover off there is what we're asking for and what is required is notification of 1 month before your intended effective adoption date. Just a couple of things to unpick there. That 1 month, it's at least 1 month. You don't have to wait until it's 30 days before you want to adopt the code and then tell us then. We'd like you to tell us as soon as possible that you intend to adopt the integrity code. So don't have to wait till 1 month. Tell us now if it's in 6 months' time. The other thing is, in terms of your intended effective adoption date, Nigel and Tennille will get into the mechanics of amending your constitution or passing a resolution. That resolution can nominate a date that is in the future. You will have, once you adopt, 12 months to achieve compliance with most of the minimum standards. But in addition, in setting your effective adoption date, that can be a date in the future. So you can meet next week and say, our intended effective adoption date is March 2026. So again, the date of your constitutional amendment or the date of your resolution doesn't have to be the date of your effective adoption. Why do we want a month? There's a few reasons for that, and it basically relates to understanding where you're at in your journey. So we want to understand the nature and the structure of your organisation. So, and Nigel and Tennille will get into the many weird and wonderful variations there can be on how a sport or recreation organisation might be set up. But we want to understand that from our point of view. How straightforward, difficult, in between is it going to be to pass this resolution, to amend your constitution, and more importantly, bind your members? Because we are dealing with organisations on a day-to-day basis, which means the team here have built up a really good knowledge of how to effectively engage and work with different organisations with different structures, but we need to understand how you'll set up. Some of you will have an absolute flat structure with just one set of membership. Some of you will have multiple tiers. Some of you will have very brand new constitutions. Some of them will have cobwebs on them and will be from 1908. So we need to understand what your setup looks like. We also need to understand your ability to bind members. Again, sometimes a simple constitutional amendment or a resolution will bind all the way through. We want to understand what that looks like. So again, we can see what's effective. At a really substantive level, the conversation, which is probably most important for us, is to have a conversation with you about your current integrity capability and where those gaps are. Because often what we've found is people get a bit of a pleasant surprise when they engage with us around the minimum standards and what they need to achieve. They actually realise they're not too far away in a number of areas, and those gaps that they have to fill are maybe fewer than they thought. It allows us to assess what your integrity capability is and say, look, you need some attention or focus here because you're this sort of sport, you have this sort of risk, and you're really lacking in an area, let's call it match fixing or competition manipulation. You've got nothing in that space, let's fill that gap. You've done a lot of work in child safeguarding, but your gap lies over here. Or your dispute resolution process is basic and needs some improvement. That'll allow us to target where we think the gaps are, and you can use your time most effectively rather than just doing a complete top to bottom review, we can work with you identifying where are the gaps and where can we get you to those minimum standards most effectively. And then the last thing I'll say before I hand to Nigel and to Neil, what communication strategy will be most effective for your members? Sounds like a really practical thing, but it's something that we've found through our engagement process so far. Understanding how you engage with your members, where your members are, how they receive information, how they respond, how you're best going to get buy-in is really, really important. That strategy is really important. And I'll wrap up at the end around some of the concerns, but I'll give you a teaser here to say one of the things we hear the most is, if I adopt, what happens if something goes wrong at that club right down the line that I've never heard of, who have never had any engagement with? There's a good answer and response to that around the approach we take to integrity gaps or where there's been failings. But probably the initial point to understand up front is let's try our best to get that communication strategy right so that we are reaching those members at that little club in the corner of New Zealand. How are we going to reach them? And that won't be a one-size-fits-all approach. Each sport and rec organisation will have a different way of reaching their members, and we've had a lot of practice at communication strategies now around the integrity code. So we're happy to work with you around the best way to talk to your people. So that's a bit of a frame up, and now I'll pass to Nigel and to Neil to get into the adoption weeds. So thank you, the Gibson Sheat team.
Thank you, Paul. Kia ora koutou, and thank you to the Commission for having us and to everyone for joining us. Yes, when we started, we thought there's not much to this. It's pretty simple, but actually the more you dig into it, the more interesting in the weeds it gets. So we thought, because there's such a range of people attending this webinar, a good starting point is to understand what's required of you in your capacity. The Commission's preference is to achieve a cohesive whole of sport approach. So that means their preference is for a national sport or recreation organisation to adopt the code. And then the members of that NSO or NRO who have adopted the code, they will be automatically bound. They don't need to adopt. They do need to think about their members because they've got to take reasonable steps to bind their own members down the chain and so on and so on. Now, those other tiers of members and other individuals, they will be bound by being members of organisations who have adopted, or they might agree to the code applying to them, and we'll go into that detail of the cascading binding later on. So if we can go to the next slide. As Paul mentioned, there's two options to adopt. They come under Schedule 2, Clause 4 of the code. And taking either of those methods of adoption, they've got to set out three things so that the organisation expressly adopts the code. Next, that it requires its member organisations to take reasonable steps to bind their members and so on. And we'll talk about the ways that you can do that. And then lastly, it's to specify the date that the adoption of the code will take effect. So before we go through those two options in detail, Nigel's going to talk about the different membership structures that NSOs and NROs might have to understand how we bind the members.
Yeah, thanks to Neil and thanks, Paul, for your introduction as well. The starting point to determine what you might need to do really requires you to look closely at your membership structure. And of course, you've all been doing that over the last years as you've been looking at the incorporated societies regime and how to go about re-registering. And it's something that Sport New Zealand has put a lot of time and effort into as well. But I thought I would just give examples of three of the more common types of structures that might be out there. For those on the webinar, you will likely fit into one of these three, but of course there are many variations of them as well. So for the purposes of today, these are probably the more common of them. So starting from the left-hand side with the blue structure there, you know, that is really a very simple structure, and it's a great structure in terms of adopting the integrity code because, in fact, there will be automatic binding of the people who are the individuals or the one tier of membership of that organisation. So really that's great. That's done. So that's a very suitable structure for adopting a integrity code. The one in the middle is also pretty good, because what that does is it makes the people at the lower tiers, the entities and the people at the lower tiers, also members not only of the tier above, but of the national organisation. And so we have a situation where the national organisation adopts the code, and that automatically binds its members. So that will apply to the regional organisations, the clubs, and the individuals in that example. So again, that's great as well. The third example there on the right side, the green, is probably what you would see as a more traditional federated structure. So that's where each level is only a member of the level above. So individuals are members of clubs, clubs of the regions, regions of the national organisation. So in terms of adopting the code, when the national organisation does that, yes, it will bind the regional organisations who are directly its members, but it won't bind the clubs and the individuals or anyone else in any lower tiers. So that's a really important start of recognising what you need to do. So if we now move to the next slide. Yeah, so what are the considerations here? So thinking about that right-hand diagram, how would you cascade the obligations through that membership structure? And this is something that we've been thinking about for quite some time. So the Incorporated Societies process under the 2022 Act has been going for some years. And of course, we knew that also at the same time, the Integrity Sport and Recreation Act was also in process. But we had to anticipate in a way what might be included once the commission was set up, and it wasn't established until the 1st of July 2024. But of course, many organisations could already be re-registered by then. So we anticipated what might be in it without knowing for sure. So we put in a whole series of cascading clauses in those template documents, which you will find on the Sport NZ website. Many of you have seen them. Many of you may have used them as a base for your processes, which is great. So if you've got those clauses in them, in your constitutions, you'll see that they were predicated by the word if. So they had no consequence if the national organisation didn't adopt an integrity code. But if it did, then they're automatically in play. And so they cascaded that requirement down through the various levels. So that's really great. If you've done that, you've given yourself a huge head start. But for those that haven't, we've now got to consider the third bullet point on that slide, which is, what are you going to do? How are you going to get down to these lower tiers and levels? Will you require a constitutional amendment? Or will you amend your membership conditions? And it really depends. It's a question for each organisation to ask of itself and say, well, constitutional amendment, we've just gone through that process with the re-registration under the Incorporated Societies Act. Do we want to really do it again? It takes time. It's costly potentially. It's just another thing that we have to do on top of everything else. So you might say, no, we'd rather not do a constitutional amendment. We would like to favour a simpler approach. And that would be deciding to amend your membership conditions. And that can be done by amending the policy, a membership policy that applies. It can also be done by putting a clause in the annual renewal requirements whereby people sign up to a requirement that they are bound by the code. So there's a couple of ways of doing that, and potentially you could do all three, but I'm not advocating that you need to do all three. But if you wanted to raise awareness, keep it top of mind for people, you could potentially do more than one of those things. So really that's the decision to be made, and the rest of this webinar from our perspective is to try and help you implement whatever decision you make under that third bullet point.
Nigel. So I'll just return to the NSO NRO level of formally adopting the code. So the first approach would be by constitutional amendment. So you'd firstly review and follow the process for amending your constitution. As you'll be aware, having probably done that recently or about to do it before the 5th of April, that will involve calling a general meeting and getting member support to pass a resolution to change your constitution. We've set out in this slide some example wording that you would include in your constitution that complies with the requirements of the code. So firstly, stating that you adopt the code and then stating a date in the future that the code will take effect on. Then stating that the members are bound, which they are automatically bound under the Act. And then the third paragraph is what Nigel was just talking about, is how you will cascade that obligation to agree to the application of the integrity code by your members. And so there's the two options set out there. So including that in your members' constitution, they must include their own clause that agrees to the application of the code to them and their members. Or secondly, that your member organisation would amend its own membership conditions. And there's a slight quirk in both of them in that if in the what colour slide, the green diagram of the traditional federated structure, just to make sure that those membership obligations or the constitutional amendment obligations cascade downwards, that's why you must require that your members include similar clauses in their constitutions or in their membership conditions, just to make sure we get right through the sport or recreation to bind those individuals at grassroots. If you've got a flatter structure, or if all individuals, clubs, regions are members of your national organisation, then you don't need to include that paragraph 3. So then just next slide, please. So the second option is adopting the code by formal resolution of the national organisation. So the board can pass a resolution to adopt the code, but we just want to put a caveat in there just to double check that your board's powers to do that aren't restricted in any way under your constitution. It's largely expected that your board would have the power to make bylaws and regulations such as the code, such as adopting the code and implementing all those policies that you will need to. But it's always good to double check, and then you'd reference that power, the clause that grants you that power in the resolution itself, and follow largely the same format as you would if you were doing constitution amendment. So I'll pass back to Nigel just to go through the cascading requirements at the other levels.
Okay, so this is the form of resolution that can be used for the first level of organisations that are members of the national organisation. So they'll normally be a regional sport organisation or a regional recreation organisation. They are normally the ones who are next in the level down, not always. So this is just a set of wording which could be used exactly as it sits there, or that's what we'd recommend. And it simply does, as Tenille did with the Constitution clause, just ensures that this requirement binds not only itself, because it's already bound anyway, the RSO and the RRO, because they are members of the national body, so they're already bound. But it then requires that their next level of membership below that level are also bound, and again also bind their members. So it just keeps ensuring that it gets below the level that it immediately addresses each time. So it just keeps moving downwards. And so, this is, once again, the resolution is to include all of that in your constitution, Or the resolution is to amend membership conditions and require that then cascades down to the next level. So you've got a choice again, but it can just be done by resolution. And then this resolution wording is simpler again. This is for clubs or whatever is the lowest tier of incorporated bodies in your particular sport or your recreation. And so this can be quite simple because there's nobody else below except their members, which are the individuals. So it's a shortened version of the page before, and that's all you need at that level. So that's pretty simple, and once again reflects the requirements by whatever method you do it. So it's either by resolution or constitutional amendment, but it just flows down to the level that's required, and this is at the very bottom level. So do this and you're all good. I think it's Paul now.
Okay, it is me now. I was speaking into the mute world. So thank you to Neil and Nigel. Really helpful. And look, you will see these slides subsequently. There's a lot of words there. There's a lot of different options. Take the time to track your structure through. And as the team at Gibson Sheat have taken pains to say, have a look at what your situation looks like, because there are a lot of words and a lot of options there. But if you have a flat structure, it might be pretty straightforward. And similarly, your constitution might be really permissive. Equally, what we have seen with some constitutions is that there are different hoops to jump through in terms of passing things. It's not as straightforward as all that. So have a look at your situation first, and by all means, reach out to us if you're not sure. What I did just want to touch on the back of that, and that this responds to a bunch of queries we've had around, okay, we've adopted. What does that then mean? So I won't get into the minimum standards. That's a webinar for another day. But I did just want to, at a high level, just talk about some of the expectations we have and how that lines up with what you can achieve. Because one of the things we hear is, and I promise you everyone in the sport and recreation community in New Zealand says this, and it's true, we rely largely on volunteers. We don't have a huge amount of resource. We don't have a huge amount of funding. There are corners of our sport or rec activity that we find it hard to reach. We know people are playing or engaging in that activity, we don't have a direct line into them. What can we do? We don't want to get in trouble. We don't want to be legally liable. We don't want to be accountable, etc., etc. I suppose the comfort around that is, firstly, liability is not the right way to think about it. From a commission point of view, we'll be partnering with you and supporting you reaching these minimum standards. It's certainly not in our best interest to have organisations falling short, and you have, from the date you adopt, 12 months to reach compliance with the minimum standards, and we will be supporting you every step of the way to make sure that you can get there. So that's the first point to make. The second point around liability, we're not a prosecuting agency. We're not going to fine you. We're not going to order compensation. What we're going to do in relation to organisations is try and get you back on track. If there's a gap that we need to fill with resource or training or guidance or advice, then we're going to work to do that. But that's going to be our response. There is a disciplinary panel, and individuals can be held accountable if they're causing a harm in that sport or activity, which means that something needs to change. But at an organisational level, it is all about supporting you get to those minimum standards. So what does that mean in terms of the key obligations you've adopted? What can you do, bearing in mind you can't do everything? The key obligations, we would say, particularly that NSO level, create and execute a plan to communicate to all of your members about what it means for them. The best way, I suppose, to fall short of the obligations under the Integrity Code is for people within your sport or activity not to know about them. So you need to work through, and this can be in advance of adoption, ideally, and certainly through that 12-month compliance period. Think about who you want to reach, how you want to reach them, how they best digest information. Are you telling them what it is they need to know around what are the behaviours that are prohibited, what is not permitted, what is not allowed, what are the avenues for support, what are the obligations that they need to meet in terms of notifying issues of serious concern, as an example. So how are you getting that information out to them? We can work with you to provide that information and package it up in a way that's digestible and work with you to execute that communication plan. And the second part, at that NSO or NRO level, providing support to help put those required policies and guidance in place at all levels. So again, we have, if you go on our website, there are templates for policies, there's guidance around behaviours, particularly in the safeguarding space. There's an absolute wealth of resource on our website. Use it, access it. That's what we're there for. That's what we're funded to do. We're set up to provide you with access to the guidance and support you need around that policy stuff and the behaviours that you need to have in place. And it's really important as well to understand, if you've invested time and money in having good policies and guidance and structure in place, it doesn't matter that your wording or your approach might be slightly different to our templates. We're absolutely fine with that. So it's not a case of us saying your comma's in the wrong place with that policy, chuck it out. If your policy gets you to the right place and we think it meets the minimum standards and you're giving good, clear direction and guidance, then that's absolutely fine. We don't want you to spend your very limited resource on reworking policies that are already effective. We might have some tweaking, some guidance, some additions, but you don't need to worry that, gee, I've spent all of this money and this time and effort getting us to a good place, and now the commission's coming along and it's no good unless it has their logo on it. It's just not true. If we think it substantially achieves what it is it needs to achieve under the minimum standards, then that's fine. And at a practical level, what should you focus on? The minimum standard, which I suppose sets the bedrock for what we're trying to achieve, is prohibiting behaviours. So be really clear to your members about the behaviours that are prohibited under the Integrity Code. That's not the same as saying, you know, swearing blind. These things will never happen within your sport activity or recreation activity. That's not what we're asking for. The Crimes Act says plenty of things aren't permitted. They still happen. Similarly, what we're looking to do through a prohibited behaviours policy is make a really clear statement that certain things, certain behaviours, certain conduct is not permitted, it's not allowed. So focus on making that really clear amongst your members about what is expected. Second point, support having good safeguarding practices in place. That is probably the biggest risk area. That's the experience we've had through consultation, through working through the legislation and the adoption process so far. That's where the most work needs to be done, and that's where the biggest risk lies. So having good safeguarding practices in place, particularly for children, young people, adults at risk, having those good safeguarding practices in terms of behaviours. It might be overnight stays, it might be changing room behaviour, it might be digital communications, thinking about the issues and the risks that might rise in your sport, and then some really fundamental things around checking or vetting and police checking and making sure people who are working with young people in particular under certain circumstances, they've gone through that process. And similarly, that they've had access to good training. So that's a real focus area. If we're going to call out an area that's going to take the most amount of work, then you need to start early thinking about it. It's safeguarding. And then the last piece, establishing clear channels for reporting issues of serious concern. The thing is, you can have all the policies in place in the world, you can have all the guidance in place in the world, but unless people feel comfortable and confident that then when they see something that maybe isn't consistent with a policy or a guidance or a piece of advice, they can call it out. Do they know, and are they feeling confident? I know who to go to, I know how to report it, and I think my issue will be heard. If you have a really good channel for reporting issues of serious concern, then that will go a long way to addressing the real harm that we're trying to minimise. So I could sit here and list a million different things you might want to do, but those are the three things that I would focus on at the start. Prohibit the behaviours that are really clearly prohibited under the code. Focus on safeguarding. That's where your biggest risk lies. And if someone sees something that isn't allowed, that isn't permitted, that is a threat to integrity, they know where to go. There's a good channel for them. So that's the obligations, as I say, in a really small nutshell. And then lastly, I'll just touch on some of the adoption lessons learned, because we've worked with organisations, and I think it's important that they don't just learn the lessons out of, I suppose, the processes we've gone through, that you all benefit from that. So I've sent those out there. Understanding the constitutional challenges and differences in terms of binding members. So understand what you can and can't do under your constitutional structure. Don't just assume it's the same as everyone else. Have a look at it, blow some dust off it, see what it is that permits you to do what, and see how you bind your members. Invest time in identifying where the gaps are before you design and implement your integrity work plan. It can be overwhelming to say, I've got to go from 0 to 100 miles in 5 seconds, and I've got to achieve all of these things. invest some time in some gap analysis and work with Danny and the team here to say, where should we focus our attentions rather than just trying to do everything? The comms strategy, I've already talked about that. The concern we often hear, I don't have direct access or control to that part of my sport or recreation activity. Come up with that communication strategy, and again, work with Danny and the team around what might suit your particular organisation. Same with the lack of funding and resource to implement those new policies and guidance. Come to us around templates, around advice, around guidance. And if we haven't prepared it already, if we get a bunch of sports coming to us saying, there's a real gap here, then we can look at coming up with a product or a piece of guidance that maybe addresses multiple concerns. So if you think there's a gap and you think you just can't get to an issue that addresses something fundamental in the code, call it out for us. We'll either have it, or maybe it's a good idea that we come up with it, but we can't anticipate those things unless you come to us. Next point's a reminder for us, I suppose, and I can do so again in this webinar. An integrity gap won't be met with a punitive approach. We're not looking to punish organisations for not getting integrity right. We're looking to support them to get integrity right. And then the last one, employment obligations and the integrity code. We get that question a lot. And so we and our disciplinary panel in particular, when they're in full operation, are specifically excluded from getting involved in employment issues in terms of ordering remedies or handing down sanctions that are in conflict necessarily or direct conflict with employment obligations. But that's not to say that you can't work on your integrity issues and still have that employment process or those employment obligations potentially operating in parallel. What we aren't mandated to do under our legislation is go in there and ignore employment law and do things that conflict and undermine the employment relationship. But at the same time, just because there might be an employment issue doesn't mean that we can't have a role. It's very, very likely that we do. We just need to be conscious, and we find this in our day-to-day work since 1 July 2024, that where there's an integrity issue within an organisation, there might also be an employment issue. The lesson we've learned is that can be a tricky path to navigate, but it's a path we can navigate. So again, if you have a concern about how those two paths might operate or work together, sing out to us, have a conversation, and we'll talk about how it might work. And lastly, links to resources. So you'll get these slides. So yeah, you can get out your phones and take photos of them now, or screenshot, or do all sorts of other exciting things with technology, or at your leisure, you can get these slides and click and access them. As I say, I'd be very much encouraging you, in addition to the code and the Constitution templates, jump on our website, have a look at the resources we have and make use of them. And if there's questions or gaps or queries that you have, then definitely sing out to us. And as was intended, we've left a little bit of time, I think, for questions and answers. So we're at that point now.
Yes, there's a question come through from North Canterbury Netball Centre. Thank you, guys. Do you have a checklist of sorts to help us identify gaps in implementing the code?
The short answer is yes, we certainly do. And Danny may want to speak to this himself. Yeah, go for it, Danny.
So there's a couple of things. One is the code adoption process is outlined quite clearly in our adoption guide, which is available online. If you'd like a hard copy, then we can organise that. The second part of that is each individual minimum standard, the 6 minimum standards, has their own checklist available. And those are also available via our website, of course, our resources page. Essentially, the only one that's a little bit different in there is minimum standard 6, which is providing or communicating to your members, which Paul talked about there. But in terms of picking up all of those checklists, minimum standards 1 to 4, which we're actually going to cover off in another webinar just before Christmas, have their own checklists. Minimum standards 5 and 6 don't require them.
Yeah, and what I'd say to that, minimum standards 5 and 6, those apply straight away. So from the date of adoption, cooperating with the Commission and communicating with your members, those obligations apply from day one. Minimum standards 1 to 4, which as Danny says, we'll dive into those in more detail at a later webinar. very much ones that you have 12 months to reach compliance with those minimum standards. That said, from day one, from adoption, to the extent that there's an issue that arises in relation to the integrity code, our disciplinary panel could potentially be a resource that you might want to access, and you can obviously continue, whether you've adopted before or after, continue to use our resolution team. That's another probably key message to pass on. There's most organisations out there have not adopted or are not about to adopt, but that does not mean they can't use our resolution team and take advantage of their skills and their processes. So very much continue to do that. And the level of complaints suggests that that message has already been received to a very large extent. So please do continue to get in touch with us about that.
I think, and I'll throw to Neil and the team shortly, but I think one thing I'd like to add is that we, in the audience today, there are a number of national sporting organisations. There's also a lot of clubs as well. And one of the questions you might be asking is what initiatives could we put in place now before our national body looks to formally adopt the integrity code? And the answer is you can get started using any of our resources to increase your capability at club level in any of the minimum standards, but predominantly most people will sort of head towards that safeguarding space, obviously the prohibited behaviours space, and the complaints management processes. So I do encourage you, regardless of where your national body is at in terms of the formal adoption process, to look at what initiatives could you put in place now that align with the code, so that when that formal adoption and governance process does take place, you're in a really good space to meet minimum standards very easily. So unless you have any comments on that, Nigel and Tennille, is there anything else that you've been sort of mulling while we've been talking that you want to add to the conversation?
Oh, look, I would just agree with your last comment, said Danny, that the clubs should be talking to their regions and their national body about having aligned processes where possible. If they're similar at all the levels, that's great, right? So it makes it easier for everybody. And I suppose you do want to avoid any surprises or anybody expressing concern down the track that they weren't sufficiently made aware of what was happening. And so that's the communication piece. But the resources that you have are terrific on your website, and I thoroughly endorse anyone going to have a look there. Just have a little hunt around for whatever, even if you're not looking for something specific, you'll find there's a wealth of information there.
Brilliant. Okay, thank you, Nigel, and thank you, Tennille. Just one final call for questions. Put them through in the next few seconds if you have any last questions. Look, I would say just continue to have conversations with us around any areas of uncertainty you have about the integrity code. We've talked today about adoption, we've talked in the past about communication, and we will be talking in the future about, I suppose, the really specifics of the first 4 minimum standards with a particular focus on child safeguarding. But if you have any queries or concerns, reach out to Danny and the team. We're very keen and happy to help. I think we're probably there. No more questions, so that's good. We're doing this again on the 20th. So if any of your colleagues want to join the live version of that, I'll be wearing a new shirt, my second best shirt, on the 20th. So tune in for that. And Tennille and Nigel will be joining us as well. So feel free to contact any of your colleagues if you want to get them or encourage them to join along. And equally, if you want to just do this all again and some burning questions have arisen to you in the intervening 8 days, might see you again on the 20th. But otherwise, I'd just really like to thank you for attendance. Danny's given me the finger of pause.
A very, very late question come through. Thanks, Simon. A little bit off topic, that's fine. Will New Zealand develop a sport integrity app similar to Sport Integrity Australia around anti-doping and being able to check medications? Short answer is we're using our website as the app at the moment, but I know our community engagement manager is online listening to this, so Andrew Taylor, that might be one for you, my friend.
Yeah.
We'll certainly take that request on board. Thank you.
Yeah, if we wanted to make enemies, we could promise things on his behalf, but we won't do that. But we're very much aware of the SIA app, and yeah, it's a good tool. Yeah, nothing else. Okay, I'll leave it with Johnny to close us out. But yeah, thank you again to Nigel and to Neil for their help and assistance. You'll see them again online on the 20th. And in the meantime, I'll just pass to Johnny to close us out. Thank you.
Ka pai, no reira, I runga I tēnā whakaro, a tēnā no tātou tō koutou, a tainga mai ahi nei, nā koutou tēnei kaupapa, I rangatira ai, reira tēnā koutou. So big thanks again for your attendance. You elevate this webinar, this kaupapa. So big thank you once again. Here's our closing karakia. Ka whakairia te tapu, kia wātea ai te ara, tūruhi whakataha ai, tūruki whakataha ai, haumie, huie, ai.
Ka kite. Thank you, team.
Yeah, we've had a couple of great questions, and thank you everybody for your attention so far. Very much appreciated. The first question, which I might direct towards to Neil and Nigel, if you wouldn't mind, is would you recommend that the adoption, I imagine formal adoption, be made via the constitutional amendment option, so that it is clear to all members, especially new members, and they're clear to them that the code applies to them?
Yeah, thank you. It's a good question, and I'll give a typical lawyer's answer of it depends. I think we wouldn't recommend one way or the other. Both are possible, both are going to achieve the outcome. It's really what's going to be best for your sport or recreation structure and the members in your system that are needing to then make constitutional amendments or membership condition changes. A constitutional amendment is a really good way to signal to members that you have adopted it, but I'd also say the number of times a member might read your constitution is probably relatively few. And one of the minimum standards, minimum standard 6, is providing information to your members about the integrity code, and that minimum standard does apply from when you adopt the code. So I think, as Paul had mentioned in his slide, having that communication plan ready is actually going to be part of your preparations for getting ready to adopt anyway. And so, yeah, really what works for you, how's your membership fatigue levels around general meetings and things like that. You might still have time before the 5th of April to put in those anticipatory clauses in your constitution or not. So, yeah, it depends. Does anyone want to add anything?
I could just add to that, to Neil, that although the choices are either or in terms of the adoption process, you can do more than one, right? So you could have the constitutional clauses in there, you might have them already, but you might also have a requirement, say in your application for membership or in your annual renewal process, which talks to this as well, and just confirms again that people agree to be bound by it, and it just keeps a high level of awareness about that for them. You might also amend your policies as well. So yeah, don't necessarily limit yourself to one or other. And of course, there's going to be a lot of communication with members anyway. So it all just reiterates the position that we would like to see.
And that's right. And the only thing I'd add to that is we see a bit of a parallel there with the sports anti-doping rules. So you will often see in constitutions the sports anti-doping rules called out specifically. I've seen that in a number of constitutions I've seen. But also the sports anti-doping rules will be called out specifically, potentially in membership forms and registrations. So yeah, it could be in your constitution, but it's unlikely that that's going to be, and that would lead to an AGM if it's a constitutional amendment and there's certain publication requirements around that. But taking that additional step of having it in a registration form and other ways of letting people know, certainly the sports anti-doping rules is a good example where I see that occur in multiple places. And if you just had it in your constitution, that might not have the level of publicity that means people understand what it means.
Thank you, guys. Great. There's another question here, a little bit longer and not necessarily totally related to code adoption, but I think it's a great question from David. In establishing clear channels for reporting issues of serious concern, what does the Commission or the Code advise organisations on issues that may be allegations of serious crime? And I'll paraphrase a little bit. I guess the question is, at what stage should organisations go bypass the Commission and go straight to police to avoid launching an investigation or perhaps starting something that may cause further issues if it is not investigated correctly? I wonder if, Paul, you could start at that point.
Yeah, that's a really good question. And through the consultation, the police were really clear to tell us, not that we didn't know it anyway, that reporting an issue of serious concern to the Commission cannot ever be a substitute for reporting it to the police if you're dealing with serious crime. So let's take the really obvious and extreme answer. If you had child abuse and evidence of that, you would report that straight away to the police. And you must do that. You should also report it to us as an issue of serious concern. But we have, we're about to sign off on an MOU with the police, and we have very clear communication channels with them. And it's a really good thing to be aware of, that we would not, for example, wade in and start investigating a matter and stuff up the evidence around a criminal investigation. So we're super aware of that. We still want to know about that issue of serious concern, but if you think you're dealing with criminal activity and err on the side of caution, you must report that to the police, and the obligation to us is not a substitute for that. That said, we still want to know about it, but you can be assured, because we have these very direct conversations with the police, reporting it to us will not lead to us wading in and stuffing up evidence and, I suppose, endangering or prejudicing an investigation at that criminal level. And if you're just not sure, err on the side of caution. Tell the police, tell us. And certainly, if you didn't tell the police, if you told us and it's an issue of serious concern because you've either got it wrong or misjudged it, then we have obligations and abilities to refer under our Act. That means if something comes to us that's criminal, then we will refer that to the police or Rangatamariki or DIA or Customs or whoever it might be that's operating that criminal space. But we're not a prosecuting agency, so if something makes that threshold from an individual accountability, it will go to a law enforcement body, that's for sure. We may still have a part to play after that, in the sense that, okay, individual A has been held accountable, they may have been fined, gone to prison, whatever else it might be, but we might have a role to say, well, how did that happen within that sport? Do they need more training, guidance, whatever? So we'll address the risk going forward. But if that individual needs to be held accountable under the criminal law, that's by another agency who we will have a very close relationship with. Good question.
Yeah, great question. Thank you, guys. Tennille, Nigel, not sure if you've got anything to add to that. No? Beautiful, thank you. Final call for questions, guys. If you've got anything you'd like to add into the Q&A, please do that. While you're thinking, I'd just like to reiterate a message that we mentioned at our last webinar and also throughout the various conversations that myself and my team have had in the sector. And the message is that irrespective of the formal adoption process, there is nothing stopping organisations from engaging with our resources right now in relation to those minimum standards and making a start on that gap analysis that Paul mentioned earlier on, and getting familiar with some of the resources that we provide, especially those resources around checklists for the minimum standards, and even more importantly, the guidelines that we have for some of those minimum standards, particularly around minimum standard 2, which is our safeguarding, related to safeguarding. So lots of resources to support organisations at all levels to increase their capability. And I think one of the things that Paul mentioned during one of his slides was analysing your current states to find that gap analysis for the minimum standards. One of the things we've found in working with organisations throughout the sector is that most organisations are not starting from zero. They're actually a lot way further down the track than they thought they would be when they looked at the code in isolation. So I do encourage you to familiarise yourself with the integrity code, with the minimum standards, through our resources, through our checklists, and in particular have a look at some of the education resources and the guidelines that we have that can be quite valuable for your communities if you are looking to increase that capability. What that means long term is that when your national governing body, whether that's an NSO, NRO, or whoever is above you, decides to formally adopt the code, you're well and truly ahead of the game in terms of those minimum standards and that overall compliance. So that is the message that we've been sending out to our team. Just checking the Q&A box, there's nothing else that is coming. So yeah, please feel free to reach out to myself and my team through that Integrity Code support email address. And we're more than happy to answer any questions that you have. Stand by, one more. I don't thank you, Sarah. Sarah's just put another link in the Q&A for links directly to some of those minimum standards. So Paul, unless you've got anything else to add, we can finish up and hand back to Andrew Tara for closing.
I'd just like to thank again to Neil and Nigel for their support around this, and for so many of you coming out on a Thursday night to give up your valuable time. It is appreciated, and yeah, we acknowledge the amazing work you guys are trying to do in your organisations. Anything we can do to help, we'll do it.
Tēnā koe pō tira, tēnā tātou. I'll now close off our webinar with a karakia. Kia tau, kia tātou katoa, te ata whai o te wāhingaro, me te aroha o tētahi ki tētahi, me ngā manaakitanga o te wā, haumi e, hui e, pā e ki e. Ko Maria, kia pai te pō.